DeWaal here, and this is Bridging the Week for August 17th to 21st, and today is August 24th, 2015. Good morning. Last week was a week of many firsts in the financial services industry. CME Group brought its first actions against an employer for failing to supervise its employee for engaging in alleged disruptive trading activities, while both an employer and an employee were charged for alleged pre-hedging block trades. Separately, the CFTC granted its first exemption from registration as a derivatives clearing organization to an overseas clearinghouse clearing swaps for certain U.S. persons, while the Commission also brought its first case against a swap dealer under its new failure to supervise provision intended solely for swap dealers and major swap participants. We have a lot to cover this week, so let's get started. In two cases of first impression, CME Group exchanges brought and settled charges against the company for alleged disruptive trading activities by its employee and against another company and its employee for the employee's alleged pre-hedging of block trades entered into for his employer. In a disciplinary action brought by the New York Mercantile Exchange, BTG Pactual SA agreed to pay a fine of $50,000 US for the alleged disruptive trading practices of an employee. According to the exchange, on multiple occasions from January 2013 through February 2014, the employee entered into orders in palladium futures contracts on one side of the market without the intent to trade. Instead, said NYMEX's Business Conduct Committee, the orders were entered into, quote, to encourage market participants to trade opposite the smaller orders entered by the trader that were resting on the opposite side of the order book, end of quote. The trader allegedly canceled the large orders on the one side of the market, and he obtained fills of the smaller orders on the other side of the market. NYMEX BCC said, quote, BTG failed to ensure that its trader conducted these trading activities in compliance with exchange rules, end of quote. In another disciplinary action brought by NYMEX, Coke Supply and Trading and its trader, Arian Fouquet, settled charges that on 4 dates in January 2014, Mr. Fouquet pre-hedged through CME Group's Globex platform block trades with a proposed counterparty prior to concluding such transactions with the counterparty. Specifically, after being solicited to enter into a block trade, claimed NYMEX, Mr. Fouquet pre-hedged the proposed transaction on Globex in order to lock in a potential profit for his employer. This violated CME Group's prohibition against using non-public information regarding block trades prior to execution. To resolve this matter, Coke agreed to pay a fine of $50,000 US and disgorge profits of approximately $51,000 US. Mr. Fouquet agreed to pay a fine of $15,000 US and be barred from trading CME Group products for 5 business days. The Commodity Futures Trading Commission charged International FCStone Markets LLC with failure to adequately supervise the swaps trading activities of Gregory Evans, one of its former swap traders, who entered into 30 unauthorized bilateral swap transactions with one customer from January through July 2013, and other members of its Kansas City Energy Group. Specifically, the CFTC claimed that FCStone failed to provide adequate oversight of Mr. Evans and the other members of the Energy Group, maintain adequate policy and procedures to ensure that discretionary trading for customers was appropriate and adequately controlled, and implement existing policies and procedures that require an individual with supervisory duties to work on the Energy Group swap sales desk. The CFTC settled its action against FCStone for the firm's agreement to pay a fine of $200,000 US. 2 months ago, the CFTC settled charges filed against Mr. Evans for his alleged unauthorized swap transactions. The alleged unauthorized trades were claimed to have caused approximately $1.2 million US in trading losses for the aggrieved customer that were later reimbursed by FCStone. This was the first case that CFTC has brought under its new express failure to supervise authority applicable to swap dealers and major swap participants. Promontory Financial Group agreed to pay a $15 million US fine in order to resolve certain allegations made against it by the New York State Department of Financial Services. Just 2 weeks ago, the New York State Department of Financial Services issued a report stating that Promontory, quote, exhibited a lack of independent judgment, end of quote, in connection with a review of the compliance by Standard Chartered Bank, one of its clients, with anti-money laundering requirements on which the New York State Department of Financial Services relied. The New York State Department of Financial Services also claimed that certain testimony by Promontory witnesses during the course of the department's investigation into the firm's conduct, quote-unquote, lacked credibility. When it issued its report, the New York State Department of Financial Services said it would deny all requests to provide the firm with confidential supervisory information, quote-unquote, until further notice. In settling this matter, Promontory acknowledged that, quote, in certain instances, end of quote, its review of Standard Chartered did not meet the department's current requirements for consultants performing regulatory compliance work for entities supervised by the department. Promontory agreed that, going forward, quote, any report it submits to the department must be objective and reflect its best independent judgment, end of quote. To settle this matter, which never took the form of a complaint or a formal administrative action of any kind, Promontory also agreed not to take on new consulting arrangements for 6 months, requiring it to obtain confidential information under New York law. ASX Clear Futures received the first order of exemption from registration as a derivatives clearing organization by the Commodity Futures Trading Commission in connection with its clearing of certain swap transactions for certain U.S. persons. The order extends solely to the proprietary swap positions of U.S. clearing members or any U.S. affiliate of a non-U.S. clearing member, including for interest rate swaps denominated in U.S. dollars, euros, Japanese yen, British pounds, Australian dollars, and New Zealand dollars. And finally, the Bank of New York Mellon Corporation agreed to pay sanctions of almost $15 million U.S. dollars to resolve allegations by the Securities and Exchange Commission that its retention of 3 interns during 2010 and 2011 constitutes violations of the anti-bribery and internal accounting control provisions of the Foreign Corrupt Practices Act. One of the interns was unpaid. The SEC claimed that in order to maintain and expand business with an unidentified Middle Eastern sovereign wealth fund, the Bank of New York agreed to retain 3 family members of 2 government officials who were both senior officials affiliated with the sovereign wealth fund. None of the interns, claimed the SEC, met the quote-unquote rigorous criteria of the internship program ordinarily administered by Bank of New York. Bank of New York violated relevant law, claimed the SEC, by, quote, providing valuable internships to relatives of foreign officials to assist it in retaining and obtaining business, end of quote, and by not having a system of internal accounting controls, quote, sufficient to provide reasonable assurance that its employees were not bribing foreign officials, end of quote. To resolve this matter, Bank of New York agreed to pay a fine of $5 million U.S. dollars, disgorgement of $8.3 million U.S. dollars, and prejudgment interest of $1.5 million U.S. dollars. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article, and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWaal. Have a great week, and ciao!